Okay, today is Monday, June the 6th, 2022, and welcome to week number week number five of constitutional law. I'm Professor Richard Wright. Um, you know, um, if my attire looks like it's a little different, it's because I'm in a hospital gown. The background you see is our usual, but I'm in my hospital room. And I have these things on my arms and things like that. Friday, had a very serious problem. I was rushed to the hospital. Turned out I was having a heart attack, and they had to rush me in Saturday and did a um, what do they call that thing? Um, anyway, where they check your veins to see, so they did that, and then they discovered that I had a complete blockage of my main artery and that I was a dead man walking, and that's why I was in so much pain. So they ended up uh, clearing that out. And since that time, I've been in the hospital uh, dealing with the post effects of it and not fully recovering. Not supposed to be typing a lot, but I got my doctor's consent to do this. So I'm going to make sure that we get this done. I did go in and provide um, some of the grading for week number 4, which you uh, just completed yesterday. Those of you who haven't, you see zeros there, but hopefully by the end of the week I'll be able to finish out as I normally have been every week. But I'm going to attempt to give you this lecture about Module 5. Before I start, I do want to remind you that we are coming to the end. Um, there are some people who might try to reach out to me and haven't done anything prior to this. I can't help you at this point because the course ends a week from Friday. So I it'd have to be determined if there's a justifiable reason for a incomplete, but if not, then I won't be able to help you. But do feel free to reach out to me, as I've said every week since the beginning of this course, to reach out to me with any questions, concerns that you have regarding the assignments by text, email, text, calling, or email. At this juncture, even though I'm in the hospital, you can still text me. My phone is still right here, and I have it, so you can go into it and you can reach out to me. So let's go in, let's share my screen so we can go over week 5's assignments. There it is. All right. So let's look at the grade book. And you can see I still have this number for week 4 to grade, 6 written assignments, and 5. And then there are 4 that are missing from each one of those. And the same with live classroom submissions. Of course, the discussion, you can't do anything with that, so because the forum is over. So week 5, this week, we're going to concern ourselves with the Sixth Amendment trial rights. And we're going to deal specifically with making sure that you understand the rights that you have at trial, the right to an attorney. We'll talk about speedy trial, things of that nature. And then your live classroom subject is due Sunday, along with your written assignment. Your initial post is due tomorrow night, and your reply post due Saturday. Okay, so let's take a look at the calendar. And you see from the calendar, there is today, where we are the 6th. You see that your initial post is due tomorrow night. Your reply post is due Saturday. And then your written assignment is due Sunday along with your written phrase. Note too that the 13th, which is a week from today, is our last lecture, and that your assignments are all due by the 17th, not the 18th, not the 19th. Unless you have an extension that has been granted by me, you still need to reach out to me and I'll determine whether or not, if you haven't done a lot of stuff beforehand, I'm not going to be granting it. You know, if you have some other issues, you might reach out to your advisor or your dean. But the point of the matter is we're at the junction now where the course is about to conclude. And so I encourage you to get those assignments in, as I've done all week, all term, rather, should I say. Okay. So let's go to and look at the announcement for this week, week 5. So the Sixth Amendment and government authority is what we're going to be covering. And to prepare for this, I already previously sent you chapters 11 and 10 of the text and the criminal justice system, the textbook. And we're going to cover the Fifth Amendment, obtaining information legally, Sixth Amendment, right to counsel, scope of the right to counsel and concept of the speedy trial. And then we'll deal with a knowledge check. Again, your lecture is taking place now. Be sure to participate in the discussion assignment, Right to an Attorney. Initial post due tomorrow night, 11:59 p.m. Central Standard, and your reply post Saturday, 11:59 p.m. Central Standard. Finally, your written assignment, the Sixth Amendment and trial rights, is due the Sunday coming up, which is the 12th, I believe. And then your key phrase. Remember, as I've said before, pay attention to the rubric, pay attention to the Blackboard lessons tab, and then, of course, listen to what I add to that in the lecture. A lot of students try to finish it without that, and they mess up. So I've encouraged you to continue to be strong, and I encourage you now to finish strong. And my motto, adversity is springboard to success, as you can see now, it's in action again with me. So let's do this. Let's do it the way that I expect you. Okay. So now let's go to week 5. Let's first look at the written assignment. Okay, so the written assignment is to prepare a 1 to 2-page flyer concerning the Sixth Amendment trial rights as relate to counsel, speedy trial, and other basic rights. And I'm going to talk about that tonight. Locate your state rules of criminal procedure or a state that you've selected. So with that, you're going to create a 1 to 2-page flyer. Now, listen to me good. In that flyer, you're going to explain when the right to counsel applies to those suspected of criminal behavior. Be as detailed as possible, okay? Be sure you have sources to support. If you cite cases, use the official full court case citations that I've shared with you before. And it's very, very, very important. And I'll be mentioning some of those tonight. Discuss the speedy trial requirements and the common time frames that we will be talking about from initial to arrest to trial. That also you'll discover in your state Speedy Trial Act that you decide to use. Explain what the criminal complaint, indictment, or information is all about. Discuss the confrontation clause. Explain what it is, where did it come from, what's the benefit of it, and analyze the scope of media access. You should be aware of the First Amendment right of the media and the freedom of press, but it's balanced with the Sixth Amendment right of individuals to a fair trial as well. And then it's APA, which means citations in the body and references at the end, a reference page, a cover page. Make sure you have that. And then finally, it must be in a Word document. No other format is acceptable because I can't run it through to check Grammarly. That's the only format that works. You must do it. All right, you must get it done. All right, here is the rubric. Again, I focus on mastery. An outstanding explanation of when the right to counsel applies to those suspected of criminal behavior, with details through understanding of the right. So I should be able to pick it up and see you gave me good information, you supported it with citations, and that will be for that section. If you don't, you're going to end up over here. You don't want that. Students always ask, is it that much? Yeah, because if you pay attention to it, it tells you up front what you will end up losing. All right, you lose 50% of this 18%, which is 9. So you don't want to find yourself in that situation. Same thing with speedy trial. Same thing with explaining the criminal complaint. And then the confrontation clause and media access. Provide credible sources and make sure it's at least one page flyer. Okay, don't just throw me a little piece of paper together. I can tell. Otherwise, you're going to end up over here. So let's get that straight. All right, so that's the assignment. All right, don't complain about the weight. If you follow the instructions, you don't have to be worried about that. It's a good habit to develop. Trust me, you'll thank me down the road. Discussion, folks, the right to an attorney. There's a scenario here that you're going to apply. For your initial post, you're going to discuss the right to an attorney, when it would apply, when it not apply, whether it applies in this scenario, how to handle comments like, do you think I need an attorney? I'll talk about that. Or should I get an attorney? I'll talk about that. Discuss the 2-week rule, which might apply in this scenario. I'll talk about what the 2-week rule is and where it came from. Support your position with case law. And if you do, remember what I said, cite your cases, cite your sources properly. Okay. All right. Now, one thing I did say, I'm not dogmatic about citing references in discussion posts. So I won't penalize you, but it's a good habit for you. But remember, that's due initially tomorrow night, which you must post first, and then your reply post is due Saturday night. All right. Let's get to, then you have your live classroom phrase that I'll be giving to you. Then the link where you can find the recording. So we're going to talk about these topics: the scope of the right to counsel, concept of a speedy trial, and the Sixth Amendment trial rights. And then we'll do just briefly a knowledge check before we adjourn for the evening. Okay, so let's start talking about the right to counsel. Now, one of the things that you should be aware is that there is a leading case that is not in here. We're going to go back to, let's go back to this scope of the right to counsel. There we go. So in the scope of the right to counsel, you should be aware of a case that's not mentioned here. Gideon, Gideon v. Wainwright. That's Wain Wright, just like my name. 372 U.S. 335, where the court ruled that the Sixth Amendment requires U.S. all states to provide attorneys to criminal defendants who are unable to afford an attorney. All right. Now, very important case. So we're going to talk about here from this point, in addition to adding that, using these questions that will be answered before this night is over. And you arrest the person on a Friday, and you jail them by 11. The question is, when do you have to have your report completed? When does the suspect have a right to appear in front of the judge? And must the suspect sit in jail over the weekend without review? So we'll cover these now. So we've already talked about the right to remain silent and Miranda and how important this procedural due process right is. Now we're going to move into another aspect of the same, the right to an attorney. That goes with Gideon. So as you're aware, that just like the right to remain silent, the right to an attorney also applies when a person is in custody. That is, they're not free to go, they're under arrest, okay? And that's, you're going to make sure you use that in order to interrogate them, otherwise you know what happens. So if they request an attorney, it ceases, it stops. You don't continue with it. If you continue with it, you're going to violate the Sixth Amendment as interpreted by Miranda versus Arizona, because they have a right to counsel, with the prodigy of dealing with the Gideon versus Wainwright, and directly in Miranda. Okay, so it says in the Sixth Amendment, the assistance of counsel. That's where that came from, and adding it into the Miranda warnings. So it's consistent with the constitutional rights, and failure to do so could result in statements being suppressed by this defense attorney. I've done many of those where individuals didn't follow the proper processes under Miranda, and I filed a motion to suppress, and the evidence would be dismissed and not used. And oftentimes that results in key evidence sufficient to be able to try and get a conviction of an individual. All right. Now, as you should be aware, we talked before that the right to counsel now is a personal right, and it has to be invoked by the suspect. No one can do it in their place. Remember, we talked about the right to remain silent. The same thing applies to the request for an attorney. All right. And it must be forthright and on point. And it is very important that it be direct and not indirect. We'll go through some examples and I'll show you what I mean in a little bit. Questioning cannot occur unless a person recontacts police and waives the right, or 14 days. So you're going to see how that is applied in the situation here, that you can reinitiate questioning, not by going back to the person, but if they've been given them, decide not to talk, released, and 14 days pass, or they come back to you, then you can then re-Mirandize them. Make sure you give them fresh Miranda warnings, and then question them in from there. And these are some cases that will help you with that. All right. So I'm not going to get into the right to counsel activity. This is an activity that you can go through and take some time, but I'll just show you what it looks like, and then I'm going to get out of it. And if you start it here, and it tells you and explains how it works, okay? So the key thing is, as what I've already covered about right to counsel, make sure that the individual requested it, make sure they're specific, and then from that particular point, no more questioning unless you go through the 14-day period or the person comes back themselves. You'll see that when you go over that. So let's talk about what is speedy trial. All right, so the other issue in the Sixth Amendment gives an individual a right to what we call a speedy trial and ensures that the individual in that process has their rights protected from beginning to end. Generally goes with a series of hearings such as an initial appearance. Now, an initial appearance, generally what happens is that the person is given the opportunity to post bail, and then the charges are given to them as well. And then the next would be either arraignment or motion hearings. Motion hearings is when we file motions to suppress or motions to provide for a psychiatrist for the individual or various reasons. There's a multitude of pretrial motions that attorneys can file to eliminate evidence or either to receive information in what we call a discovery motion. That's the overall document that's filed, or disclosure motion in some jurisdictions where the prosecution has to turn over evidence that they have in their possession. All right, so the trial based upon the Constitution makes it clear that speedy trial and a public trial, which means that the public is allowed. Cameras are now involved in a lot of them, but even before that, the media and other individuals, it wasn't a private courtroom or anything like that. They could only remove people who were disorderly or something like that, or if they didn't have space. But the fact of the matter is, it was open to the public, except in juvenile cases. Okay. And a jury trial if the individual so desires. Again, it does not apply in juvenile cases. All right. And it must be in the district or in a county where the act took place. So there is what we call the Speedy Trial Act. And the Speedy Trial Act kind of helps the individual to not have time stretched out. Because keep in mind that you are presumed innocent until proven guilty. So would it be unfair for you to be incarcerated 90 days and then later on it's determined that you didn't do the offense? That's why they want to minimize those kinds of things. That's why you have a attempt to bail and things like that. But notice what it lays out is that the average um, um, state felony case, and I can verify that, is 9 to 13 months to be resolved from arrest. And the reason is because of the nature of the defense obtaining evidence from the prosecution. And the more complex the case and the charges, and what based on what the court docket is, and the prosecutor's caseload will kind of stretch that out. Now, to help in federal court, there is what we call the Speedy Trial Act of 1974. And the act requires an indictment is filed within 30 days of arrest and trial, and has to commence within 70 days and not less than 30 days from the indictment date, requiring at least 30 days between indictment and trial commencement. Okay. So I already kind of elaborated on the reasons for a speedy trial, but I'll throw in a little bit more that the Ewell case laid out some reasons. There's a 66 case that this guarantee is important to the safeguard to prevent undue and oppressive incarceration before trial. I kind of talked about that a few minutes ago. Minimize the anxiety and concern about the allegations or public accusation. And then finally, to limit the possibilities that long delays will impair the ability of an accused to defend himself, because witnesses disappear and die and stuff like that. And then people forget the longer it takes before a case goes to trial. A violation of the speedy trial provision results in charges being dismissed, i.e. the Dickey versus Florida case, a 1970 Supreme Court case where Robert Dickey was charged with bank robbery as a federal offense, but previously he had robbed a gas station, but the state did not prosecute him because they said, oh, he's in custody for a federal trial, and saying that he was unavailable. That's not good, because they had the right to get him and do that at the same time. So the Supreme Court said, no, Mr. Prosecutor, Mrs. Prosecutor, Ms. Prosecutor, said that Dickey is right. His Sixth Amendment speedy trial rights had been violated, and the robbery charges were never brought and dismissed. So in addition to the reasons that I have given, the key thing is to further the interests of the public, integrity in the system, as I said, victims and availability of witnesses, timely resolution. And then one that I haven't is to minimize overcrowding. Remember, you're incarcerated for something that is determined that you did not do later. That's bad. The more time between charging and trial can negatively impact witnesses' ability to remember things, to come forward, and can adversely affect testimony, prosecution, and defense, but really with the defense. So there is somewhat of a timeline that's set out, and this is where I want you to pay attention to. It says there is not one university accepted because before trial commences, but most have patterned themselves after the Speedy Trial Act in terms of various jurisdictions. And so that, for example, in Wisconsin, an arrested and jailed person must appear before a judge or magistrate within 48 hours of arrest. So to answer your question is, over the weekend, they should come before a judge before that Monday. A preliminary hearing to establish probable cause commences within 10 days if the individual is in custody, or 20 days if they're out of custody. Once again, to get the process going. And then finally, the Sixth Amendment right is to be fairly given so that trials are timely heard and due process is satisfied. All right. Now, be aware that one of the most important things to keep in mind in this concept is to try to get the person to trial as quickly as possible, but also adequately prepare your defense if you're a defense attorney, have your case properly prepared if you're a prosecution attorney. Now, having said all of that, if the individual's time runs out, too bad. You can't try the individual. The Speedy Trial Act in the jurisdiction would be a bar, no matter how egregious the charges are. The public might be upset, but the public should also appreciate the purpose for these Speedy Trial Acts is to be fair to both sides. All right, and here's the site for the Ewell case that I mentioned earlier. All right, let's get to our final area, and that is the Sixth Amendment trial rights. Now, We've kind of gone over them a little bit, but as we already talked about, the right to counsel, speedy trial, uh, then other rights to be informed of the nature and cause of the accusation, and that's usually in writing through an information or indictment. The right to confront witnesses, you'll see that in the Constitution. The right to cross-examine and to elicit the truth or veracity of the witnesses to demonstrate integrity in the system. All right. So it says here from the Sixth Amendment, in all criminal cases, to be informed of the nature and cause of accusation. That's the information or indictment. To be confronted with witness against him. So that means you can confront the allegation charges, cross-examine, question those individuals, use what we call compulsory process, and that's usually referred to as a subpoena or subpoena ducis tecum. Subpoena ducis tecum means that not only would you come, but you bring documents if there are any documents or any items that need to be brought forth. And those are usually involved in check cases, documents, and things like that. To have the assistance of counsel, as we've already talked about as well. All right. And so the criminal complaint, as we've talked about it, there's 2 points to add to that, is that it requires the complaint, which gives the charges, and then the affidavit contains the facts about the case to determine if probable cause exists, so that the judge can determine if it's probable cause to bind the individual over for trial. So here we are I was talking about a person being arrested on that Friday, and it says that the criminal complaint is presented, and if the court's not open on weekends, a common mechanism is to have a judge over the weekend to review probable cause charges. But the judge reviewed the statements and determined if probable cause exists not more than 48 hours after the initial appearance. The exception is if there's a bona fide emergency or if there's a very complicated situation that's involved in the allegations and charges in the case itself. All right. At the initial appearance, the judge doesn't determine probable cause, but the judge ensures the defendant gets a copy of the complaint, advises the defendant of their right to counsel, determines bail, and schedules the next appearance, such as a preliminary hearing or arraignment. All right. So probable cause hearings will come later in the preliminary hearing in that situation. Finally, as I said before, the defendant will have a right to cross-examine the witnesses to determine whether or not the witnesses are credible, and 3 points based on the Maddox case, the 1895 case. Number 1 is to ensure witnesses are testifying under oath and subject to perjury if they lie. 2, allow the defendant to question the witnesses who testify against them. And 3, to allow jurors to determine the credibility of a witness by observing their behavior and demeanor. So that goes back to the confrontation aspects of it. Okay, so for example, at a preliminary or probable cause hearing, law enforcement officers often testify to determine whether it's probable cause. The defendant, through their attorney, questions their law enforcement officer about the facts. The order of question depends on who the witness is testifying. If the witness is testifying for the state, then the prosecution will examine on what we call direct examination, and the defense will cross-examine that same witness and vice versa. Okay, and the judge rules on objections and things of that nature. All right. So finally, the Sixth Amendment rights, with others that we previously discussed, are elements of due process. So to make sure that there's a fair and fundamental opportunity of the individual. And it also makes it possible that it's understood that it must be proven by beyond a reasonable doubt that an individual committed an offense in order to convict them. Okay, and we've already talked about the right to counsel, the probable cause hearing, and so if the defendant says able to convince the court that there is no probable cause, then the charges are dismissed. If not, they go forth. And then here are some cases. So it's very important for you to understand the rights that those individuals have. So let's do a knowledge check, see what we learned. Let's begin by asking these questions. Which statement is an example of a clear invocation of the right to an attorney? I don't know. Should I get an attorney? I want an attorney. Maybe I need an attorney. Do you think I need an attorney? Is this a clear invocation? Do you think I need an attorney? I don't think so. Maybe I need an attorney? Probably not. I don't know. Should I get an attorney? How about I want an attorney? That's as clear as you can get. And that's the correct one. Which is the correct application of the 2-week rule established in the Maryland versus Schatzer case? You know, where a person's in custody and then they release and then they question them again. An in custody defendant who has requested to remain silent cannot be interviewed again. Well, we know that's not true. If an individual is wanted to remain silent and cannot be interviewed again. But what about this? An in custody defendant requesting an attorney was released and re-interviewed after fresh Miranda warnings was waived. How about that? There it is. So in custody is required, and the request honored, and law enforcement waited the 2 weeks for a fresh series of questions. According to the Speedy Trial Act of 1974, an indictment must be filed within how many days? I'll just save you it's 30. What is a valid reason for preserving the speedy trial rights? We talked about those. So, to increase anxiety associated with jail time, to increase anxiety, to help prosecutors prepare for a speedy trial, to prevent undue incarceration prior to trial. Okay. So I'm going to stop right there. So you now have an understanding about how this whole thing works. Let's stop sharing and let's come back. And so now I hope that you got a clear understanding about this week's assignments and topics. Again, feel free to reach out to me. Oh, you want to say, okay, Professor, what's the key phrase? Okay, write to an attorney. That's it. Write to an attorney. Write to an attorney. Give me that and you get your points for this week. Get those assignments completed. Again, if you have questions, feel free to reach out to me, even though I'm going through. Just reach out to me. I'll be happy still to help you, even in my situation. So that's all I have for tonight. Enjoy your week. Take care of yourself. Stay safe. And I'll see you next Monday for the final lecture. Good night.